about so many people gathering outside. Yesterday you said it had become a literal mob, not a figurative mob. Those were your words when you resurrected your 8th motion for mistrial just on that issue.
Well, I'm not going to discuss the security precautions that have been taken by the court. I don't think it would be appropriate. There's been a lot of work done to ensure, if not the anonymity of the jurors, their privacy. It's hard for me to respond to that right now.
Why you wouldn't want the jury sequestered? You can't say?
Whether the jury needs to be sequestered depends in part on what arrangements have been made as we speak today with respect to the jurors, and I'm not going to discuss those. Not that I am necessarily privy to all that, but even if I was, I just don't think that we need to be having that conversation right now while the jury's deliberating, and I'm sorry if that's frustrating, but that's just the best I can tell you right now.
I understand. We'll respect that. Let's move on to something else that has a lot of people talking, as I'm sure you know, and that was your colleague, in this case, Laura Hogue, who represents Gregory McMichael. She made the comment yesterday in closing arguments about AHNAUD Arbery's toenails being long and dirty. And it got a lot of discussion after the court proceedings had concluded for the day. AHNAUD Arbery's mother, very upset, feeling that it was a disparaging comment. We're curious, what did you think of the comment, please?
Well, what I think is that Laura Hogue is an excellent attorney. She's provided incredible representation for Greg McMichael. And I'm not in her shoes. I'm representing a different client. So it's hard for me to speak to what she did. On behalf of Mr. Bryan, I probably would have not commented on that. But then again, I represent a different client, different situation. And all I can tell you is she is a fine lawyer. She has a great legal mind, and everything she does, I feel pretty confident in saying it's thought out. Sometimes difficult things need to be raised. If the lawyers are afraid to talk about it, how can you expect the jury to do that? And I don't know if that impacted her thought process. I don't know what the thought process was. But I would be reluctant personally to be critical of such a fine attorney without knowing exactly what the thought process was. But you also got to remember now, I'm sitting behind the other attorneys as they're giving their closing arguments, and I can't see what y'all are seeing during the trial. You also have to remember, this is a challenging case for the lawyers because of the masks that the jurors are wearing in the courtroom. We can't get the usual feedback. And, I think certainly for you and some of the other folks at Court TV, you can appreciate the importance of having that feedback. So without the benefit of that, sometimes it's harder to assess or predict what's going on with the jury. So, I don't know what impact that had on the arguments that were or were not made by the other lawyers yesterday. Understood.
Tell me, we know one of the very highly contested issues outside the presence of the jury was the admissibility of a statement that Travis McMichael allegedly made after AHNAUD Arbery was shot and killed using an expletive and then the N-word. And we know ultimately, because of a very famous case in the United States of America, the Bruton case, if your client, Roddy Bryan, was not going to take the stand and be available for cross-examination on that because he's the only person who would be able to relate that, it can't come in against Travis McMichael, even though it's his statement. And we unpack this a lot here on the show, Mr. Goff. And, I am wondering about something that Travis McMichael's attorneys shared with Court TV just a few days ago when they came on our programming, and they said it's their belief that your client never heard that statement made by Travis, that he was just saying this to investigators in order to procure a deal for himself. Your response to that, please.
Well, my response to that, and I know you're going to be frustrated with me, is that the jury's out in this case, and I'm not going to discuss the evidence that was presented in front of them, nor am I going to discuss evidence that was not presented in front of them until they've returned a verdict. Yeah, there's a lot I could say in response to all that, but I just don't think this is the time or the place. maybe we'll have this conversation again later.
Okay. And
because I don't want to do or say anything here that could negatively impact the co-defendants. They also have a right to a fair trial.
Certainly understand that. We respect that. And we, of course, would invite you back on any time you are available for us to talk about some of these issues that you just cannot legally discuss today because of the situation. And right now with this jury out deliberating for an hour and 51 minutes. So with that, just want to say thank you very much for your time, Mr. Goff. Thank you for making time for us. And we'll let you head back into the courtroom and hopefully get a chance to speak with you again soon.
Thank you so much. Have a good afternoon.
Take good care. You as well.
The verdict clock remains up. We have 2 hours, 50 minutes. The jury's been out. We're going to take a break. But coming up, we will turn our attention to the youngest victims near and dear to my heart. A mother who says she had brutal abuse from the boyfriend, a former NFL football player.
Are you one of the millions of people living with bladder control problems and on Medicaid? Then stay tuned for a special free offer from Active Style. How would you like to have all your incontinence supplies delivered discreetly right to your door at no cost to you? And with free shipping, you can, thanks to Active Style.
Hello. At Active Style, we understand your needs, and we're here to help. We offer convenient home delivery of a variety of products for bladder control and incontinence issues, and they may be available at no cost to you if you're Medicaid eligible. When you call us, a personal incontinence consultant, someone like me, will help you find the right product that is both comfortable and makes you feel secure. In fact, your comfort and satisfaction is assured by our Get It Right guarantee. Plus, your supplies can be delivered discreetly right to your door for free. And best of all, our caring and complete service costs you nothing if you're Medicaid eligible. So let us help you. Make the call and Active Style will find a product that is just right for you. If the fit is not right, we'll send different products until you are completely satisfied. That's our Get It Right guarantee. Your privacy is assured. Our incontinence products arrive direct to your door in discreet boxes, so you can forget about making those embarrassing trips to the store. Plus, Active Style will take care of any paperwork and personally follow up to check on your supplies to be sure you don't run out. If you or someone you know is incontinent, let us make life easier. Call now. And if you're Medicaid eligible, we'll also send you a free sample. You'll get great caring service, our Get It Right guarantee, and a free sample, all when you call right now. This is a special TV offer, so please call now.
If you're on Medicaid, call now for your free sample. We'll ship your incontinence supplies discreetly to your door, so no more embarrassment at the store. Active Style is the most convenient way to get your incontinence supplies, and it costs you nothing.
Have your Medicaid card ready and call 1-800-258-4373. That's 1-800-258-4373. Call now.
George Foreman here to fight for you and make sure you're getting a Medicare Advantage plan with all the benefits available to you. That's why you need to know the Medicare and prescription drug plan annual enrollment period is now open.
George, does that mean I can update my Medicare plan?
That's right. Now's the time to call to update your coverage and see if you are eligible for new Medicare Advantage plans that may include dental, vision, hearing, and prescription drug coverage.
Did you know that you may be eligible to get up to $144 added back to your Social Security check every month? It's easy to see if you're eligible. Just call the toll-free number on your screen now and get a free Medicare benefits review. Just call 800-718-1984 now.
George, I keep hearing we don't automatically get new Medicare benefits. Should I call to see if I'm eligible?
Yes, you should do what I did. I made the call and spoke to someone who was so helpful. Just call the number on your screen.
Call now to see if you're eligible for plans with additional benefits, like free eyeglasses, free hearing aids, free rides to appointments, free telehealth visits, or even an over-the-counter allowance.
Plus, you could be eligible to get money added back to your Social Security check every month. Now that's a knockout.
George, do you think I can really save money and get extra benefits?
I'm so glad you asked. You may be eligible for a plan with $0 premiums, $0 deductible, and no co-pays. Don't miss out. These are the final weeks to enroll, so make the call now.
Thanks, George. I'm calling right now.
I made the call, and you should too. There's no obligation to enroll. The call and Medicare benefits review are free.
Just call 800-718-1984 now. That's 800-718-1984.
Now for a disturbing story on the youngest victims, and in this case, a mother. Ex-NFL player Zach Stacy is out on bond after being arrested last week after a video posted online appeared to show him attacking his ex-girlfriend, Kristen Evans. I watched this myself when it came out. I couldn't help but watch because of the youngest victims in this case. Now, the video, which Evans shared on social media, was taken from her surveillance camera inside their Florida home, and it appears to show Stacy punching her, the mother, in the head and then throwing her into a TV while their 5-month-old son was literally just feet away. Before we show you this video, we do want to warn you that it is graphic and some viewers may find it disturbing.
No, I do not. Please, please, please.
You thought that was okay? And you're going to ruin relationships and come out undestructive?
Listen, things are way different now.
The former Jets running back has been charged with aggravated battery and criminal mischief in connection with the incident that you just saw. Still with me to help break all this down, trial attorney Krista Ramey. Krista, you may know that I have been a juvenile court judge. I'm a child welfare law specialist. That 5.5-month-old was in the bouncy right next to where all of that was happening. So I must first ask, do you see any potential charges against him as what he appears to be the aggressor in that video, doing all of this right next to a baby?
Yes, I do, Judge Ashley. I think that there's potential child endangerment charges that could be brought. I know that, he was arrested on aggravated battery, I believe, or assault. I think that what you have now is a prosecutor that is looking at every frame of this video and will be coming up with the most possible charges to ultimately charge neither an indictment or a criminal information. This is just outrageous. I mean, that baby right there could have gotten hurt. Unbelievable.
Right. It really is. Now, as the reason I do this youngest victim segment, and I'm so thankful the producers that Court TV allows us to, because part of what I believe is that education is prevention. And so I want to talk about the laws around this, because there's a difference in criminal court, criminal charges against someone who perpetrates child abuse or neglect, or in this case, child endangerment, as you just mentioned, versus our dependency system, which is all about abuse and neglect of children, and when the state needs to step in to help protect children. In this case, it appears as if from that video that the mother is clearly the victim in this case. But is there any concern when you watch this of abuse or neglect of this 5.5-month-old because that baby's left in such a volatile circumstance?
There is. I think that it's a touchy situation. Courts, I also work with kids a lot, Judge Ashley. I don't know if you know that about me, but oftentimes have clients that have been taken away from their parents through the dependency courts here in California. And I will say that it is the last resort. They want to make sure that, that if you've got a loving parent, like you probably do here in Miss Evans, that the baby stays with her. But it depends on what steps she's taken to protect herself and to protect her child. And all indications so far is that she has filed for a restraining order against Mr. Stacy, and that she is, speaking out about this, taking steps to protect her child. So hopefully she'll be able to keep custody of her child. If she continues to go back, however, I think that you have a totally different story, because then she is placing her child in danger.
And Krista, I think the laws would agree with you. We know every state has its nuances, but to your point, a parent has to protect. They have to have the protective capacity to take the the steps necessary to protect their child. So in this case, I think my next question is, and if we had the answer to this, it could be a much safer place, but how do victims in situations like this protect their children when they may themselves be victims and not have necessarily the capacity, understanding, or knowledge to be able to know what to do to get out of that circumstance?
You know, I call this Beauty and the Beast syndrome, as women were taught from a very young age that if you love the beast, he'll turn into a prince, right? If you kiss the frog, he'll turn into a prince. You know, those things aren't true. I think that Miss Evans probably loves Mr. Stacy and wants what's best for him. She actually spoke out to, calling on Roger Goodell to do something about players who have these violent tendencies. I think that she might think that this has something to do with concussive syndrome, like CTE or something. She's looking for ways right now to forgive him, which is very scary, because that's not where she should be right now. She should be looking at ways to protect herself and her child, not ways to make this family unit work.
Krista, watching that, did you have any opinion as to whether or not this is something that might have happened before in terms of how she reacted to it, or if it might have been the first time?
The way the camera was positioned in her house, I suspect that this was done in order to catch something. Oftentimes, particularly if you have a powerful or well-known spouse, your word is not necessarily believed unless you've got signs of the physical abuse on you, broken bones, black eyes, that kind of thing. I think that she videotaped this intentionally.
Well, and, there's a lot of discussion out there, and there are experts that are available to those in need. But part of it, Krista, is this discussion around what you do if someone does hit you in that circumstance. Because if you know they're volatile, you are going to try to do something to really kind of put yourself in a position that they don't make it worse. You don't make it worse, that they don't do more to you, rather. So I want to thank you, Krista Ramey, for all your thoughts. Glad to know that you also serve the younger children, the youngest victims. This is one that's hard to watch, but I'm grateful it's out there and that we can actually have conversations around what to do and what can happen. Please, to anyone out there suffering, please know there is help available. The number for the National Domestic Violence Hotline is 1-800-799-SAFE. Again, 1-800-799-SAFE. And a reminder, we have the verdict clock on the screen, 3 hours, 2 minutes. That's how long the jury in Brunswick Georgia, has been deliberating. I want to thank attorney Krista Ramey for joining us today, and we will stay tuned here on Court TV Live.
Tonight on Closing Arguments, we are in a verdict watch in the killing of AHNAUD Arbery murder trial. Was the prosecution able to convince this jury to convict all three of these defendants? Has the defense put up a strong enough case regarding citizen's arrest and self-defense? Our teams are on the ground bringing you every update as we await the jury's decision.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV.
Hi, Jimmy J.J. Walker here. If you're on Medicare, listen to this. It's the Medicare annual enrollment period, and there's a deadline to update your coverage and benefits for all of next year. I didn't want to miss out, so I called the 1-800 number to see what Part C benefits I could get. An actual person answered and looked up my zip code, and boom! I was offered extra benefits like dental care with extractions, fillings, dentures, transportation, and so much more, all at no additional cost. And get this, based on my zip code, I can get $100 a month. That's $1,200 a year added to my Social Security check. I was like, dynamite! Call, check your zip code.
I called, and he looked up my zip code and said I could eliminate co-pays and get expanded dental care, prescriptions, transportation, and meals covered at no extra cost.
I couldn't believe my zip code has a benefit that adds money to my Social Security check. They help me so much.
It's simple. 1, call the number on the screen. 2, the agent will check your zip code to see if you're able to eliminate co-pays, get expanded dental coverage, prescriptions, transportation, and meals. And 3, They will check to see if you're eligible for the benefit that adds money to your Social Security check every month, up to $1,700 a year. Call to check your zip code and get what you deserve.
I called to check my zip code.
I called to eliminate copays.
I called to save money.
I called to get my dental work covered.
I called to get money added to my Social Security check.
Call, check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-989-5137. That's 1-800-989-5137 now.
This is an important message for everyone on Medicare. Attention, everyone on Medicare. Today we are talking about Medicare Part C, commonly called Medicare Advantage. If you don't have a Medicare Part C plan, you could be missing out on extra benefits simply not covered under Medicare Parts A and B. That's right, there are millions of people on Medicare but don't have a Medicare Part C plan, which covers everything in Part A and Part B, plus extra benefits only in Medicare Part C. Here's the good news. Everyone on Medicare can call now during the Medicare annual enrollment period. We will check to see if you are missing out on a Medicare Part C plan with additional benefits. Call the number on your screen. Don't wait. The deadline is December 7th, and phone lines get busy during the Medicare annual enrollment period. You don't get Medicare Part C benefits automatically, so call now before the deadline for your free, no-obligation Medicare benefits review. Just call 800-715-1644. 800-715-1644.
Over $50 million in prizes paid. More than 4 million pounds lost.
I'm global health and fitness expert Jillian Michaels, and I love Healthy Wager. It's a great way to lose weight by motivating you with big cash prizes. Play with a free prize calculator and see how much money you can win by hitting your weight loss goals with custom workouts and meal plans.
Join Jillian's Healthy Wager and win up to $10,000. Free access to the fitness app by Jillian Michaels and huge cash prizes at healthywager.com.
Good Tuesday afternoon. Welcome back to Court TV Live. I'm Ashley Wilcott. It's always my honor to be with you. We are in verdict watch in a huge trial out of Brunswick, Georgia. You can see it on your clock, 3 hours, 7 minutes. This jury has been deliberating. Now, this is the case in which the fate of Travis and Greg McMichael and their neighbor, William Roddy Bryan, is now in the hands of the jury. This morning, the prosecutor in this case, Linda Dunikowski, gave the state's rebuttal to the defense's closing arguments.
What was there to be afraid of? Well, let's see. Ahmaud was wearing a T-shirt and cargo shorts that were so baggy he has this big belt loop out here. Let's see what else. Didn't have a bag or a backpack. So, no, doesn't have anything that he's carrying. He was running with his hands empty at his sides. Ran away from them for 5 minutes. Did not have any weapon. Nothing on him. Didn't say one word to them. Didn't threaten them verbally. Didn't say, oh yeah. Didn't say anything. And he had no help from anyone. So what's there to be afraid of? He went this way. He goes this way, he goes that way. And you see Travis McMichael move down to the center of the street there, blocking his way. He's trying to get away, and then, oh, look, he's going to go this way. And he does. He goes around. And what do you have here? Travis McMichael going to intercept. And that shadow underneath there, I mean, you can have the stills back there. We printed some of them out. That shotgun is pointed right at him. Right at him. Okay? So when he gave the police that story about, I was at Port Arms, and he was striking me and hitting me and striking me and hitting me, and I finally, had to do this. That's what he told the police. A bunch of lies. Shotgun. Shadow right here.
Let's go now live to Court TV legal correspondent Julia Janae outside that Glenn County courthouse. Julia, talk to us first, please, about the rebuttal and Dunikowski and how she did today.
She had the floor, Judge Ashley. This morning, it was just about the state prosecution's rebuttal, but really a restating of their entire case in front of this jury. The defense ended the day yesterday, but right before this jury is going into deliberations, all they've heard on this fresh day is from the state. I think she did a good job of making sure they understand the state's summary of the law. That was a point of contention today because the defense claims that they misstated the law and made a mistrial motion in the presence of the jury. They were sent out before those arguments. Ultimately, the jury understands that this is how the state interprets the law: citizen's arrest, false imprisonment, burglary. But there were a lot of jurors taking notes, especially on the description of those three legal issues that I just mentioned.
And Julia, when you were talking about the summary of the law, I was trying to think of how to simplify, because we know, the jury does have all these definitions, and it's a lot. I respect every jury because it's a tedious job in some respects, reading the law, thinking about the facts that they find. But I wanted to try to simplify. So I'm wondering if we could look together just at the charges. We know that there are 9 different counts against each of these 3 defendants, and against one of them we have 3 lessers that are included, and that, of course, is against William Roddy Bryan. And the thing I wanted to mention on this, we know we have malice murder, felony murder, aggravated assault. That accounts for the counts 1 through 7. You see there on your screen. And then the counts 8 and 9 are the false imprisonment and criminal attempt to commit a felony. But in trying to simplify this, and I want to get your opinion, I think that really what this boils down to is, number one, this jury has to decide whether or not they believe it was a citizen's arrest. If it was a citizen's arrest, then number 2, they have to decide whether or not they acted in self-defense for each of the 3 defendants. If it was not a citizen's arrest, then I think self-defense goes away, right? So I think that one then goes away, and then they have to determine whether or not they think that these 3 defendants individually are guilty or not.
I agree that they would have to cross that hurdle of citizen's arrest if they then are getting to the conversation about self-defense, because the prosecution laid out for them that if the other party is the initial aggressor, then they don't get to claim citizen's arrest. And the way the defense is getting around that, because it's clear to pretty much everyone that the defendants were the aggressors, they were the ones going after AHNAUD ARBERRY, then this jury would then go to self-defense if they believe this was a citizen's arrest, and that's why the defendants were the aggressors. But I will say, the defense has put up this argument, probably thinking about the fact that this jury is going to have to weigh both of these defenses. They have put in place some facts that they've highlighted, and part of Travis McMichael's testimony that suggests that they had stopped chasing AHNAUD ARBERRY, that they were no longer the aggressors, despite how difficult that may be for those who have watched just that clip of the final moments of this chase. They say that Travis McMichael, when he was parked there in the road, that he was not actively pursuing Arbery, and that it was Arbery who was running towards him, looking at him, not moving one way or the other, and that he felt threatened. He felt, based on the totality of the circumstances, that's what he used on the stand, not on the day of the actual alleged crime, but he said that he felt that if he did not try to defend himself, that Arbery was going to rush him, was going to jump onto the truck, was maybe going to hurt his dad, so he was protecting himself in that moment. And then when Arbery goes around the truck, he says that he just went to look and make sure he still stayed away from them, and that's when there's that confrontation that we really can't see in front of the truck. So the defense is likely hoping that the jury, if they don't believe this was a legal citizen's arrest, that they will still believe that it was self-defense.
All right. And so let's just mention, and then I want to talk about the composition of the jury. But first, the citizen's arrest statute. And I think the language that most would agree, especially based on closing arguments, that this jury really has to decide is whether or not the offense was committed in the presence or within the immediate knowledge of the defendants, right? And I know the judge had instructed that synonymous, but that's going to be one of the main issues, I think, in this case when they're considering citizen's arrest. Let's move then, because we know, Julia, what we think doesn't matter. It's the jury that now has to make this decision. What do we know about the composition of this jury in Brunswick, Georgia?
Well, Judge Ashley, I can tell you that the latest that we've heard from the court is that the bailiff informed the pool reporter inside that they did deliberate through their lunch. So they are eating and they are still going over things. So they are keeping their nose to the grind inside of that jury room. The makeup, as far as these 12 men and women who are inside of that deliberation room, there's 11 white jurors, 1 black juror, 3 are men, 9 are women. Their ages range from 20s to 80s based on our observation. 3 alternates were set aside. They didn't know they were alternates throughout this case, but they are not in that deliberation room. That's 1 man and 2 women. They were all white alternates, and 1 was a white woman in her 50s to 60s, 1 was a white man in his late 60s, and 1 was a white woman in her 30s to 40s. This jury does skew older as far as the age range of those who are deliberating this case. They have been very attentive throughout this trial. They've written a lot of notes, taking notes even during the closing arguments, even though the prosecutor said you don't have to take a lot of notes. You really will get these instructions from the judge, but there still seem to be things that they really wanted to take into consideration, and we know their first task in going into the deliberation room was to pick a 4-person. So maybe we'll learn from some of the notes that may or may not come out who that 4-person was.
And Julia, I've been remiss because I haven't asked a really important piece of the puzzle from our viewers, from my perspective, that I want to know. We know that 3 hours, 15 minutes is how long this jury has been deliberating. But what has it been like outside of the courthouse as everyone really anxiously awaits to see what this jury does?
It's anxious, but there's a quiet lull right now. It's as if they don't think the jury is necessarily going to come back anytime soon. I think there's this expectation that the jury is going to really take their time today, so that it might be later in the day. We don't have large crowds here, but there definitely are supporters outside. It's reminding me of the first few days of the trial. There's a lot more media here than we've seen on other days. They know this is a verdict watch, so there are a lot of microphones set up in front of that courthouse. We also know that there are public figures who are going to be coming here to join AHNAUD Arbery's family, hold press conferences. We understand the Reverend Al Sharpton is going to be here again. He was here a couple of weeks ago and sparked a lot of comments from the defense attorney, Kevin Goff, in this case, but he's going to be returning here and may make some statements. So overall, very quiet outside as far as chanting, but everyone knows what's going on inside, and that's the deliberation of this case.
Oh, and I know that we need to let you go, but quick question. Did you say earlier that the judge indicated that they will stay as long as the jury chooses to later if they're still deliberating?
That's exactly right. He will let them deliberate as late as they want to, so they likely will send a note when they are ready to go home, or the judge may inquire if they have a stopping point.
All right. Thank you so much, Julia Janae, live from Brunswick, Georgia. Certainly, if anything happens there, when it does, we will let our viewers know and go straight there to Brunswick. In the meantime, we want to bring in Nima Rahmani, former federal prosecutor. Nima, always enjoy having you on. I must ask you, first, what do you think all of these attorneys, defendants, the state are feeling like 3 hours and 17 minutes into deliberations in such a huge trial in terms of outcomes, expected feelings, emotions, and the death of AHNAUD Arbery?
So what are you doing? You unpacking? Where's your dog at?
Ashley, and if you're one of the attorneys,
the dog at the house and not there with you?
If you're one of the attorneys trying this case or defending this case, you have to be on pins and needles. You're waiting for some sign from these jurors, some sort of note, a question, some way you can read the tea leaves to decide what way they're leaning, because there's a wide range of possibilities here. Obviously, you have everything from murder to lesser charges, but you also have 3 defendants, each with varying degrees of culpability. Obviously, as a former prosecutor, I think everyone should be found guilty, especially of felony murder. But you have Travis, who actually pulled the trigger, Greg, which is next in line and next most culpable, and then you have Roddy Bryant, and you saw what his attorney tried to do, distancing himself from the co-defendants, and even him filing several severance motions earlier in this trial. So it's going to be interesting to see what these jurors do and what signs they give us as the public, the attorneys, and the court as to which direction they're leaning.
And we know it can take quite a bit of time. There's so many different charges in this case, 3 defendants, to even read through all of that law. So certainly every time I've had an experience with the jury, they're thorough, which we always want and I always respect. Let me ask you, are you surprised from your experience, are you surprised that these 3 defendants, given the different facts against each one, really, no, that's not what I mean, the different role of each arguably, were tried together in one trial?
I really was. And on one hand, if you're a defendant, the last thing you want, particularly if you're Roddy Bryant, is to be tried with the McMichaels. But on the other hand, it actually ended up helping Travis, and this is why. We know that Roddy Bryant told law enforcement that Travis uttered the N-word, that racial slur. But because he asserted the Fifth Amendment privilege and wasn't subject to cross-examination, even though we, the public, know that, none of that evidence came in, and I think that would be very damaging for Travis if the jurors heard that. Similarly, the judge 403 under Georgia state law excluded the evidence of racial slurs between Travis McMichael and his friends, so none of that came in. So this case is about race, Ashley, but not as much evidence of race came in as we thought it would. So I think that was a benefit to Travis because that would have been very, very damaging, and I would have expected a very quick guilty verdict had that evidence come in.
And although the defense attorneys each represent their own clients, certainly they had to talk and have conversations around the strategy of each and how they were going to present different evidence and what else might come in depending on what they did. All right, Nima, you're going to stay with us. We want to talk about the McMichaels defense because they made one more request for a mistrial today, the 8th by Attorney Goff. We'll take a look at what that was about, and the citizen's arrest law raised an objection.
Do you owe money to the IRS? Listen to how Optima Tax Relief helped these people put their tax debt to rest.
I owed the IRS $102,000.
I owed the IRS $66,000.
It's a horrible feeling. You know, at some point in time, I knew the IRS was going to be coming looking for me.
I was paralyzed with fear.
Optima got me a settlement with the IRS.
The team at Optima Tax Relief settled my IRS tax bill.
It was every bit of a new lease on life for me to be able to get that burden off my shoulders.
They really cleared the path for me to have a fresh start, and I will be forever grateful.
And I'm still amazed. Tell the story. People do not believe it, and I have paperwork to prove it.
For your free consultation, call 800-648-4559. That's 800-648-4559.
Optima Tax Relief. $3,200 to fix your car's AC, $4,500 to repair your brakes, $5,000 to replace your transmission. Car expenses add up fast and get costly, and always when you can least afford them. Not with A+ rated Ox Car Care. With Ox, if you own a car, truck, or SUV, you don't pay for repairs. Ox pays.
Man, I'm glad Ox took care of me. I was going to be out about $2,000 in repairs. They covered it. I got my truck fixed at my own mechanic, and Ox took care of everything. I'm a believer now.
Simply give us the make and model of your car, and we'll give you a free quote right away. Ox Car Care even comes with a 30-day money-back guarantee.
It couldn't be easier. You choose where you want to have your car repaired.
And when it's time to pay, Ox Car Care handles the bill directly. That's it.
They even cover the cost of towing my truck and paid for a rental vehicle. Ox blew me away.
Not only will you get complete coverage for your auto repairs, but with Ox Car Care, you also get free oil changes, free tire rotation, and free roadside assistance.
I trust Ox Car Care. They do what they say they're going to do. Man, I trust them so much. I got a second plan for my second vehicle.
The engine mount repair costs over $2,000 on my car. Oscar took care of everything, made sure it was done right. It was great.
Don't wait. Call to speak to a friendly associate for your free quote right over the phone, and you can get coverage today.
Look, I'm a veteran. I know what it's like to have somebody watching my back. That's what Ox did for me. They even went to the dealership to discuss repair pricing. Ox Car Care is great. They have my back.
They saved me $500 on a $600 repair. Thanks, Ox Car Care.
Just call the number on your screen right now for a free quote. Call today to get coverage today.
Ox
Oxygen knows in the world of true crime, some women uphold the law, some women break the law. Both can turn your world upside down. Oxygen is home to truly bold, truly wild, true crime.
I'm so late, I couldn't drag the bar. I was in way over my head.
Everyone has a motive for watching. Oxygen. We live and breathe true crime.
Welcome back to your continuing live coverage of the case in Brunswick, Georgia, and the killing of AHNAUD Arbery. We want to remind you that we do keep up a verdict clock on your screen. Verdict watch clock, I think is a better way to say it. 3 hours, 24 minutes. That's how long the jury has been out deliberating in this case. Certainly, as soon as we hear anything from that courtroom, we will take you there live. Earlier today, the judge, Timothy Walmsley, finished charging the jury with instructions just before 11:30 a.m. Eastern Time. The state gave its rebuttal to the defense's closing arguments this morning, and there were sparks. The prosecutor, who we've been watching, Linda Dunikowski, highlighted to the jury the importance of the parenthetical citizens arrest law. That, in turn, led the defense to moving for a mistrial based on an incorrect statement of the law. Let's listen together.
A private person may arrest offender if the offense is committed in his presence. Okay? You can arrest if the offense is committed in his presence. If the offense, and that's my parenthetical to remind you, if the offense, we're talking about that offense, the one that was just committed in your presence is a felony, and the offender is escaping or attempting to escape right then and there.
That is not the law that the court's going to give, and we've had this discussion. It's a misstatement of law. We would object.
I join in the objection.
It's noted.
You understand this is my argument. The judge is going to give you the law, right? And he's going to have it written out for you, and he's going to read it to you. But this is the state's argument, that the offender is escaping or attempting to escape. The state's position is that what that means is, I saw the crime, I can't chase after the person, I just have to try and arrest them right there. But if it's a felony, and if they're escaping, they're running away, I get to chase after them. I don't get to chase after them unless it's a felony and they're trying to escape. All right? A private person may arrest him upon reasonable and probable grounds of suspicion. That's the state's position.
We have to object and have a conference with the court.
We're going to let the state continue. We talked about this in the charge conference. The objection is noted.
We move from this trial based on the incorrect statement of the law.
Your Honor, based on the final draft of the charge that the court provided us, I guess yesterday morning, the court is going to charge that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of offense or during escape in the case of felonies, his power to do so is extinguished. That's not what the state's arguing. They're arguing and it's a clear misstatement. The court should simply instruct the state not to argue an incorrect statement of law rather than putting the burden back on the jury to understand what the state's saying, what we're saying, and now what the charge is saying. The court has the power to do so and should do so.
All right, I'm so glad to still have with me former federal prosecutor Nima Rahmani. Nima, I could talk with you all day about all the legalities because I think you and I both thrive on that piece. Let's start with, though, some just basic discussion about the fact we know what statutes say and we can read them. But jury instructions are not that. They are not just a copy of the statute to say, here it is, jury, figure it out. The instructions are written based on the statute, and then both sides have the opportunity to object or not, come together. The judge ultimately decides, this is how I'm going to say it to the jury. What is the reason that the jury gets instructions versus a literal copy of the code section?
Well, actually, the jury needs to go through each of the elements of the crime, and sometimes, legislatures representatives, they draft statutes, and they're not entirely clear. So that we need to break them down, make sure the jury hits each and one of those elements. They all have to be satisfied, of course, beyond a reasonable doubt to establish guilt in a case. And there's defenses, and there's instructions for reasonable doubt and how to deliberate and all that sort of good stuff. But I really like what the judge did, and this is something that attorneys commonly do. They bicker about the jury instructions outside the presence of the jury, and then when closing arguments start, whether it's opening argument or rebuttal, the parties object. And the judge handled it perfectly. All he or she needs to do is say, my instructions control. If the attorneys say something that's inconsistent with my instructions, you're to disregard that. But judges shouldn't be getting in the middle of closing argument and sustaining objections and those types of things when there's minor differences or nuances about the law. And it's certainly not grounds for a mistrial. There's been many, many mistrial motions made in this case, particularly by Brian's attorney. And this is another one that, frankly, just misses the mark.
And I do appreciate he also put on the record, we talked about this during the jury charge conference, which, as we know, is outside the presence of the jury between the attorneys and the court, so they can make a record of everything they've discussed. Let's look at the citizen's arrest statute now that I've explained all of how the jury gets the information, because I think, and this is where I really want, Nima, you to help explain what your perspective is. The very first paragraph, Linda, the prosecutor, kept hammering on the crime has to be committed in his presence. But that first line does